this is what it's like to try to make law school videos with a 75-pound dog named Laney running around. If you are a student of mine or were, then you know who I am. If you were not or are not, my name is Professor Beery from Western Michigan University Cooley Law School, where I teach constitutional law. I've been teaching for 17 years. I want to provide a resource for law students that I think is going to be kind of unique. And what that's going to be is a series of episodes where instead of talking about what the law is, and I'll of course have to do that a little bit, I want to break down what you're looking for in a fact pattern to figure out whether you're being tested on that particular principle. What kinds of facts, and I'm going to break these down in a sort of elemental way. If you see fact 1, 2, 3, and 4 in a fact pattern, here's what you're probably being tested on. I don't want to make any promises, but that is a pretty good bet. I'm going to start at the beginning with judicial review and judicial supremacy, right, and Con Law 1. Judicial review is a weird kind of subject, you might have noticed if you studied it, right, in Marbury versus Madison and all that, where you kind of think, well, how would you test this, right? The question is, does the power of judicial review exist in federal courts? And the answer is yes. You know, how do you turn that into a fact pattern? How do you test judicial review? I'm also going to talk about judicial supremacy, which was the idea that was most firmly established in Cooper versus Aaron, the case where school districts from Arkansas decided they were not going to go along with Brown versus Board of Education, and the Supreme Court said, yes, you are. So I'm going to talk first about judicial review, then judicial supremacy, and I'm also going to provide some visual guides here for if you see the following facts, that is how we test on those principles. Let me start with judicial review. The only way I can think of to test judicial review, and again, I'm not making any promises that it's impossible, but the only way I can think of to test judicial review, first of all, would be to have Congress create some new cause of action. So the first sort of element you'd look for in a fact pattern, right, to cue you in that you're being tested on judicial review is that Congress passed a new law, right? Number one, so you have Congress as the actor, and Congress has created some new cause of action. So, you know, conferred some new right on some group of people. So that's 1 and 2. Okay, Congress and new cause of action. What I'd have to do then is develop a fact pattern where part of the new law that Congress passes empowers federal courts to hear those cases. So 1, it's Congress, 2, they make a cause of action, and 3, they give jurisdiction to federal courts to hear that cause of action. Now here's the final component that would again cue you in that you're being tested on judicial review and related ideas. Congress in its law giving jurisdiction to federal courts would have to say something along the lines of a district judge or a circuit court, when the federal court issues its final judgment, that judgment shall be transmitted to somebody else, and here's the key, and that somebody else would have the option to take it or leave it, right? So it could say something like this. Congress passes a law creating this new cause of action. If a plaintiff is injured, the plaintiff can go to district court. District court will issue a final judgment, issue it to the Secretary of the Interior, pick anybody you want. Secretary of the Interior may decide at his or her discretion whether to adopt the court's findings and judgment. There's the key. That violates separation of powers. That flies in the face of the power of judicial review, which is the power of a federal court to decide a case, right, and to require compliance with its orders. And it also touches on what we call an advisory opinion, right? If a district judge is just issuing an order that a government official can either take it or leave it, well, then essentially what the district judge is doing is giving advice, and that's not what courts are there for. So again, for judicial review, here comes Laney with her football. 1, Congress. 2, creating a new cause of action. 3, empowering federal courts, giving them jurisdiction to hear cases under that new cause of action. And 4, making compliance with a court order optional. Those are the 4 things you'd look for a question that's testing you on judicial review. Now quickly on judicial supremacy. First of all, you need a state actor if you're going to be tested on judicial supremacy. So state actor, you're looking for things like city clerk, public school official, a prison warden, a public university chancellor, governor, things like that. I need to put a state actor in the fact pattern first of all. Second, I need to have a Supreme Court, probably a more recent, but at any rate, a Supreme Court opinion that's been issued, a Supreme Court judgment. Third, I need that court judgment to be on a federal question. It cannot be on a state law question, right? If I'm testing judicial supremacy, and we'll get to the good part here soon. Fourth, as to the state actor that's been identified in the fact pattern, one of the critical things that I need to build into the fact pattern is a refusal to go along with the Supreme Court's judgment, right, in a case involving a federal question. So, prison warden, public university official, county clerk says, look, I'm not, at least questions, right, having to go along with the Supreme Court's judgment. And the reason that they're going to give, this will be in the fact pattern in all likelihood as well, the reason that state actor is going to give for not wanting to or not having to comply with a Supreme Court order on a federal question is that it was a separate case and that this state actor was not a party, right? So I was not a part of the lawsuit, how can I be bound by it? Of course, the rule is, under judicial supremacy, the rule of judicial supremacy, once the Supreme Court decides a federal question, it doesn't matter who you are. Well, I should say, it doesn't matter whether you are a party if you are a state actor. If you're a state actor, you are bound by a U.S. Supreme Court decision on a federal question. So, for example, if the Supreme Court says for one state it's unconstitutional, it just says flat out, it's unconstitutional to execute people under a certain IQ, right? If the Supreme Court says it is unconstitutional to execute a person below a certain IQ, right, then a state that was not a party to that litigation can't continue doing that because they were not a party. So let me review again, in this case, 5 components to a fact pattern that would test judicial supremacy. Again, it would have to be a state actor, some kind of state actor. You need the Supreme Court, right, issuing a judgment. You need that judgment to be to resolve a federal question, right, a question arising under the Constitution, a statute, treaty, or a federal policy or executive order, something like that. You need the state actor refusing to comply, or at least questioning the need to comply, and the reason is going to be, finally, 5th, the reason is going to be they were not a party to the lawsuit. When you see those facts in a fact pattern, you're being tested in all likelihood on judicial supremacy. Think Kim Davis, if you want to Google an example of this. Kim Davis, the Kentucky county clerk, who decided that she was not going to issue marriage licenses to same-sex couples because her county was not a party to the lawsuit and the Supreme Court case of Obergefell versus Hodges. And she found out the hard way that state actors have to comply with edicts from the U.S. Supreme Court on federal questions. One more time, judicial review. Number 1, Congress. Number 2, creates new cause of action. Number 3, empowers federal courts to hear those cases, gives them jurisdiction. Number 4, makes compliance optional. Judicial supremacy. Number 1, state actor. Number 2, Supreme Court judgment. Number 3, on a federal question. Number 4, refusal of the state actor to comply. And number 5, because they were not a party to the litigation where the Supreme Court ruled. So there you go. That's how you get tested on judicial review and judicial supremacy. So I hope that helps. And if it does help, subscribe, click like, and come back for episode 2, where I'll do this for some other early on Common Law 1 issue. Talk to you soon.